Welcome all to the first instruction class on administrative law by Dr. K. Sangeeta. When you start the introduction, the 5 themes to start out the discussion in administrative law. The first one is the bureaucratic government has existed in various degrees in nearly all organized political system. The effects of administrative government influence us literally every moment of our life. Bureaucratic government has provided no utopian cure for the shortcomings of capitalism. Administrative law seeks to reduce the tendency towards arbitrariness and unfairness in bureaucratic government. Administrative law is relatively a new and open-ended field of law. Next we will see the definition, the branches of public law dealing with the structure, authority, policy and procedure of administrative and regulatory agency. Administrative law is an important body of the US law pertaining to legal authority of public administrative entities to perform their duties and the limits necessary to control those agencies. Administrative law has been created by judicial decisions, statutes. Administrative law does not include the substantive rule and regulations that administrators make. This is called as regulatory law. The rule of law and administrative law. Rule of law versus rule of men. Rule of law, the idea that law, not the discretion of officials, should govern public affairs. Discretion, ability to make responsible decision. Arbitrary, autocratic in the use of authority. It is a quality of being determined by chance, whim and impulse and not by necessity, reason or principle. When you say fairness, it is justice. So law clearly says in the Constitution of India that justice should be maintained in its preamble. Next we will see what is law. Herbert Jacob, authoritative rule made by government intended to bind the government itself, people and institution outside government or both. Benjamin Cardozo or Oliver Wendell Holmes Jr. Law is a principle or rule of conduct so established as to justify a prediction with reasonable certainty that will be enforced by courts of its authority if challenged. The prophecies of what the courts will do in fact and nothing more pretentious or what I mean by law. According to Liv Carter, law is the legal process lawyers and judges use when they try to prevent or resolve human problems using rules made by state as their starting point. Public law and private law. Private, the rights and obligations that private individuals and institutions have when they relate to one another. Civil law, example marriage, contract, personal injury. When you say public law, it addresses the relationship that individual and institution have with the state as a sovereign entity with the structure and cooperation of the government itself. It preserves and protects citizens within its jurisdiction. All the obligations that citizens have to the government. The obligation to the government as to citizens provides security. Example, paying tax, serving in armed forces. When you see the subcategory, the administrative law, where 3 important points takes place: rule making, adjudication and administrative procedure. Next is the constitutional law and the criminal law. Next we will see what is due process. This word due process of law was earlier used by the US law. If you see the 5th Amendment, no person shall be deprived of life, liberty or property without due process of law. When you see the 14th Amendment, nor shall any state deprive any person's life, liberty or property without due process of law. If you compare this with Article 21 of the Indian Constitution, this word due process of law was interchanged by procedure established by law. When you see the types of due process, procedural due process, set of procedures designed to ensure fairness in judicial proceedings. When you see its formal definition, the minimal requirement of notice or a hearing guaranteed by the due process clause of the 5th and the 14th Amendment, especially if the deprivation of the significance of life, liberty and property's interest may occur. The second is the substantive due process. Law must be fair in content and application. The law must be just and not unfairly deprive people of its life, liberty and property. Formal definition, if you see, the doctrine that the due process clauses in 5th and 14th Amendment of the US require legislation to be fair and reasonable in content and to further a legitimate governmental objective. The 7 ethical meaning of rule of law, if you see, the constitutions are the supreme law in the US. The rule of law therefore requires the court to follow the constitution. It is similar in India as well. The rule of law requires judges to enforce statute as written. The rule of law requires judges to follow precedents. Following precedent is also followed in India. The rule of law refers to philosophy of justice, not a concept of following the law. The rule of law is philosophy of compromising and balancing among social interests. Rule of law seeks to achieve fairness, rationality, social equity by promoting public participation in decision making. Rule of law checks and shapes the power of the government by seeking the maximum feasible reduction of arbitrariness. One can say that administrative law boils down to the dialogue or political debate about just what is procedurally fair in modern politics and government. Thank you.